Any mention?
I don't think the court will take up hearings today because we're sitting till only 11:30. Yes.
Supplementary list. Item number 1.
May it please, Your Lordship.
Yes, Mr. Pandey.
Lordship, I am serving as Associate Professor in Nehu, Lordship.
What
Lordship,
happened? Was the order violated?
Lordship,
What was the order?
original order is annexed at page number 10, Lordship, Annexure 1.
Number 10. Yes, number.
The operative part will be at page number 13, Lordship, para 9.
Let them settle down.
Page number 13, Lordship. Page number 13, Lordship, para 9.
Yes.
May I read, Lordship?
Yes.
However, since the appellant says that there is a procedure for the employer reviewing the position, particularly in the light of the appellant being exonerated in the first case and the inquiry in the second case not having commenced, it will
Please
be
keep the voice down. Please keep the volume down. Yes.
it will be open to the appellant to make an appeal to the respondent university by citing the appropriate provisions, whereupon the employer will consider the same in accordance with law and communicate a decision of the appellant within 4 weeks of the receipt of the written request in such regard. In case the request in such regard is rejected, due reasons thereof should be indicated, Lordship. The court had granted 4 weeks' time, Lordship. Subsequently, I gave a representation, Lordship, which is placed at page number 15, Lordship, Annex 2. Unfortunately, even after the expiry of 4 weeks' time, no response was received from the respondent, Lordship. But the respondent filed a miss case, Lordship.
Miss case.
Miss case, Lordship. The order of is placed at page number 24, Lordship, Annex 4. Respondent requested for 4 weeks further, Lordship, time period. Case number 25, the operative party is there, Lordship. Is prayed for further extension of 4 weeks' time is granted.
November 23.
23, Lordship.
Yes.
Subsequently, I have given 2 representations, Lordship, but no
What
responses.
is this, Mr. Sen?
I'll find it. I'm appealing for
Sir,
both
Mr.
the
Pandey,
respondents.
learned counsel for the petitioner, issued notice. Learned counsel submits that the contempt has been filed for violating the orders passed by this court in. First one is in order dated 21/9/2023 in the writ appeal number 3523 and also
21
order dated
21 November 2023.
2023 passed in Miss Case
47 of
2023. Stops next paragraph. Ms. Essen, who's present, accepts on behalf of. How many
Both the
respondents are there?
respondents. Both the 1 and 2.
Both the respondents, no further notice called for. Just after 3 weeks, yes.
Deeply obliged, Lordship.
Obligement.
Item number 2.
May I please, Lordship?
Where is that person? Oh, yes.
May I please, Lordship?
Yes.
My Lord, in item number 2, my Lord, this is the second round of litigation, my Lord.
Yes.
The earlier Honorable High Court has directed to the respondent authority to consider the representation against the uncommunicated ACR of the petitioner, my Lord. The petitioner has submitted the representation, but that has been rejected legally, my Lord. So at this stage, I am praying only for notice, my Lord.
That means they had a review DPC.
No, my Lord, they have rejected my representation, my Lord, mechanically, without going through the record and each and everything, my Lord.
Heard Mr. V. Kumar, learned counsel petitioner, issue notice. Ms. A.
On behalf
Pradhan,
of all the respondents.
Vice Dr. M. Muzika is present, except mostly all respondents.
respondents.
No further notice called for this after 3 weeks for instructions affidavit. Yes.
High
My
Court. Item number
Deeply,
3.
Lord.
May it please your
Yes.
Lordship. Lordship,
Yes,
I'm
ma'am.
sorry if physically present because of the roads. What
Yes.
has happened? This is another round of litigation. Lordship, we had, if Lordship recalls, that we were asked to shift our petrol pump from the defence land, which we did. Thereafter, the government allotted the land to us, and now, when we went to talk informally, we got to know that the IOC was not willing to let us set up a B-side pump they wanted us to sublease the land to them. So, petition number 1, 2, and 3 applied for a fresh license, Lordship, and they were selected by the IOC on the basis of the land allotted by the government of Meghalaya.
Yes.
Now, Lord, but since IOC kept on insisting that we sublease the land to them, otherwise they would terminate our lease, we came before your Lordship. Lordship was pleased to issue notice, and the matter was fixed on 19/7/2024.
Yes.
On 19/7/2024, IOC did appear, but on the same evening, we got a confused email by which my selection, the selection of the petition number 2, 3, and 4 was cancelled. And this was done without a show cause notice, without hearing us.
Cancel.
On the
Where is the cancellation?
Lordship, we will find it at page 50.
Page
Annex 11. 50, Annex 11.
50.
Yes, 50, Lordship. Annex 11.
So you mean to say that after the relationship was settled with you, it was cancelled subsequently?
Yes, Lordship, I was selected, and then it was cancelled without a show cause notice, nothing. That also is a counterblast to the writ petition which we had filed, where they were threatening us to sublease the land to them or they would cancel our license, etc. When we filed there, they appeared, and the same day they cancelled it, Lordship, on 19th. We got this email. No hearing, Lordship. I mean, we could have satisfied the land in question is actually ours because the other partners have decided to retire.
Now, I see the reason given here is very small print. The last one, the land
Yes.
allotments done for partnership firm. Allotment letter
Yes.
name, partner name written Sri Ramesh Kumar Sureka. Application be submitted support on draft deed, partnership managing share partners. Applicants in
Absolutely.
the name of so and so. It's clear allotment
Yes.
is not owned by applicants. What does it mean?
Lordship, the applicants means the petition number 1, 2, and 3 apply, the sons.
But the thing
What
is
was-
that if I correctly remember, after you shifted from the Anjali side, land was allotted to you
Yes.
by the government.
Yes.
Yes.
So, and that was to my fathers. My fathers can easily either lease to
So the
to
thing
the
is that
respective.
you can't go to any other agency. It has to be in an oil only.
Lordship, we can go. If Indian Oil doesn't give us, we can always go.
Otherwise,
There's no. Yes,
and if
we
you
can
should
always
notice-
do that.
yes.
And lots of stay this for the time being. The email.
Who's appearing for the
I'm appealing
respondent?
for respondent 1 and 2. Yes, Your Lordship.
Yes. What do you have to say?
Lordship, we haven't received any instruction from IOC.
Let them. We'll list it on Monday, on Tuesday. Let them or Wednesday. Let them receive instructions. Yes.
And Lordship, till then, no, let this be stayed, Lordship.
I object, Your Lordship. No, let's receive the instruction, Your Lordship, first.
I think I'll be unfair. Anyway, we'll just heard Ms. Mazarika Listening Council. Who's assisting you with so and so? Stop. MS M. Rahman. Vice who? Who's leading you?
K. Khan, Your Lordship.
Vice Mr. K. Khan is present and accepts notice on behalf of respondents 1 and 2. Stop. Next paragraph. The grievance as set up in the incident petition is that the allotment of a retail outlet by the respondents to the petitioners has abruptly been cancelled by the impugned
Email
email
dated 19/7/2000.
dated 19/7/2024. Stop.
Yes.
It has been submitted that by legislative council that the said cancellation was out, affording any opportunity of hearing to the petitioners. Stop. It's further submitted that in another connected petition being number
224 of
Lordship, 224.
24 of
2024.
224 is pending adjudication before this court, which is connected, where the issue is connected. Stop. In interim, also prayed that the impugned cancellation dated 19th to also be not given effect to. Stop. Next by MS M. Rahman submit that she has no instructions presently and please have the matter be posted next week to enable the response or obtain instructions. Stop. Accordingly, list this matter on listed on 16th. On
16th, yes.
On
Yes,
16th,
Lordship.
on 16th, 8, 2024, till the next date, the said impugned cancellation dated 19th shall not be given effect to.
Obliged, Lordship. Lordship, item number 13 is also connected, the old matter.
So we'll list, when it comes up, we'll list it together with this one on the next date, yes.
Yes. 13 may come up with this.
Yes. Who's for the petitioner?
Your Lordship, this regarding the benefit retirements.
10 days, I'll take instructions.
Anang untuk order itu? MTC 10 days.
Item number 5.
In this matter, my lord, there are certain defects in the writ petition, my lord. I wish to, I am making a prayer to withdrawal, my lord, with the liberty to file afresh after curing the defects. I'm going for, my lord, any rectification as such. We wish to withdraw it, my lord.
Mr. S. Thapa submits that due to some serious defects with petition, he prays him not to withdraw the same to file afresh. Stop. Same objected to by Mr. Additional AG. Matter stands close on being withdrawn, however, liberty as prayed.
Obliged, Your Lordship.
Item number 6.
Yes, Mr. Vora.
Yeah, please. The case is that I have landed property and homestead in Shirakhawa village, inherited from my mother.
In?
Shirakhawa village in West Garo Hills district, under police station Rajabala. There, after my mother's demise, I was called by the Mahari for distribution of the property. And when I went last 2022 or 23, July, August 12, I went there. And then the respondent 4, along with about 15 other people, attacked us. We had to run away from there, came back to Shillong. Then on 25th August, I filed one petition under section 145, 146 before the ADM Tura. The ADM immediately transferred that petition to the SDM Dadengiri on the same date, gave me a copy of the order. The petition was transferred by the ADM officially from there. Thereafter, September, I went there, found that the at Dadengiri, the petition was not registered. Till 29th November 2023, I found that petition was not registered.
When did you file the complaint?
25th August.
25th August.
Yes.
Okay, yes.
Then 29th, 11, I went there, I found that case was not registered. Thereafter, I filed a petition under section 482 before the High Court. Then during the proceeding of that case, the government counsel, government advocate...
What order? What order was passed there?
That it is Annexure 3, my lord, at page 30, page 30. On the submission of the government advocate that the case has been registered, the case was disposed. Then recently on 27th July, I went personally to Dadengiri, found that the case was registered. After getting the notice of the High Court, case was registered as of September 2023, but the case was never put up before any magistrate till 27th July last. And when I asked the bench
That's
assistant,
why I come very
Abhijit
petition.
Hajong,
Yes, you
bench
get
assistant said
instructions.
that
Lordship.
You get instructions. Yes, heard Mr. P.K. Bora, the counsel for the petitioner, issue notice. MS NG Shilla, Sinigan advocate, is present, except notice on behalf of response 1, 2, 3.
1, 2, and 3, Lordship.
Notice issued to respondent number 4. Stop. Next part is submitted by Mr. Nekpara Bora that though a complaint under section 145 107 CRPC had been lodged before the additional district magistrate at Tura on 25/8/2023, and which was subsequently transferred to the court of respondent number 2 at the Dangre, Westgara Hills. And in spite of the orders of this court passed in, where is that? Criminal petition number
Annex 1 is the order passed by the
126
ADM.
2023.
On
dated
Annex 2.
6/3/2024. On an inquiry by the petitioner, the matter is yet to see the light of day. He therefore prays that necessary instructions necessary directions be issued for expeditious disposal of the said case. Ahmed Enshira presence, who is present has accepted notice. Has prayed for how much time to obtain instructions?
3 weeks' time, Lordship.
3 weeks time too long. 2 weeks time to obtain instructions. Just after and so and so.
Much obliged, Lordship.
Daily list item number 1.
Start.
Lordship, Lordship on limited instruction, Your Lordship.
Want to withdraw?
No, Lordship.
Then
Week's accommodation, Your Lordship. Next week, Your Lordship.
miscommunication?
Week's accommodation, Your Lordship.
Oh, neither. They like the infantry that sent first to the battlefield. Huh?
Lordship, next week. Lordship, next week, Your Lordship.
Next week.
Lordship.
You not executed as yet?
No, it's there's been some delay in the trial court, but it's matters fixed for hearing again.
On the request of counsel for the appeal is after 2 weeks.
Obliged.
Item number 2.
Where's the Devnath? You are fit and fine now. Yes. What's it for today?
For admission hearing, Your Lordship.
Chief Engineer, you've already filed. Number 7. Then, you filed affidavit, Mr. Devnath.
Yes, I filed my name.
Yes, what's it for today?
Admission hearing, Your Lordship. But I pray
Huh?
admission hearing.
Yes, you ready?
No, Your Lordship. I pray for 2 weeks' time, Your Lordship.
Why? This matter is very urgent. Who's leading you in the case?
Mr. S.M. Suna, Your Lordship.
What happened to Mr. S. Suna?
He's on leave, Your Lordship.
But are the pleadings complete? Mr. Sen?
We have filed it on behalf of number 7. Union has already filed this. I'm not sure if they want to file a rejoinder.
I have no instruction.
Rejoinder has been filed to 1 and 2. After the file number 7, you don't
We
have
are supporting the case of the petitioner.
I have no instruction, Your Lordship.
on the prayer of the counsel of the petitioner due to personal difficulty. This is matter after 1 week, yes.
Item number 3.
The limitation. Condemnation rather, not limitation.
Condemnation.
Yes.
minute, please. My lord, page 59 of the main case CRP is the petition
We don't have the main case here.
for substitution which I had filed.
How many days delay?
1686 minutes.
686.
Regarding the delay, my lord, it comes to actually 159 days because, my lord, the impugned order was passed on 12/9/2017. Then, since 20 March 2018 till 17 August 2022, this is the period when the parties had traveled the wrong path. Assuming that the order of dismissal was an order under Order 9, Rule 8. That was an error by both parties, even by the court below. That is why I had gone to the court for substitution, my lord, first.
When did you go substitution?
On 20th March 2018, I had...
Okay, he died,
I had
the plaintiff died on?
27/6.
Reswal Tariang is the plaintiff.
Yes, my lord.
Okay.
27th June 2017.
Okay, he
Expired on 27/6/2017.
He expired on 27/6/17. Okay.
Then I was not on 12 September 2017. The case was dismissed for default.
Okay, 12/09.
That was after 47 days of the death of the plaintiff.
Yes.
Then I did not know about the dismissal of the case. I met the counsel and I informed the counsel that my father expired. So the counsel advised that I have to go for substitution immediately. So on that very date, I went with the substitution petition to the court. And in the court, the court informed me that the case had been dismissed under Order 9, Rule 8.
When was that event to file substitution application?
20th March 2018. I had gone to the court.
20th March 2018, you went to file your substitution application.
For
You
substitution.
found out that your matter had been dismissed.
No, my lord, on that date, the court allowed me to correct the petition and add Order 9, Rule 9 on it, making me understand that the order of dismissal was under Order 9, Rule 8. The mistake started there.
No, please come back. Now you say what happened was this was the fault. You went on 20th of March 2018.
With a substitution petition under Order 22.
Then you
Then
on
when
that
I
date
presented to
on
the
that
court-
date were you aware that the suit had been dismissed?
No, it was not. When I presented to the court, court said, how can I take this substitution? The case had already been dismissed under Order 9, Rule 8 on so-and-so date.
So you filed
So I
substitution
prayed
anyway.
that can I add this Order 9 Rule 9 also here for restoration? Court allowed me, under the belief that the order was under Order 9 Rule 8.
So you filed substitution?
And there in the court itself, I added read with Order 9 Rule 9 CPC for restoration. That was allowed by the court, my lord.
Then?
So the mistake started there. I was on the belief that the order was under Order 9 Rule 8, proceeded accordingly, filed the petition under Order 9 Rule 9. Thereafter, COVID started. There was no court. There was no judge for a long time. Only 2022, a new judge was appointed, and the new judge took up the matter, and the case was dismissed because of these are the grounds, that it did not fall under Order 9 Rule 9 mainly. So, this wrong voice from 20th March 2018 till the final judgment in that petition on 17 August 2022, these days will be are liable to be excluded under Section 14 of the Limitation Act, my lord.
So it's only
May I read
pursuing wrong remedy and...
That I did not take the wrong path by myself. The court had led me the wrong way, my lord. Allowed me to write Order 9 Rule
where are
9.
the orders? Where, then we'll have to call
Petition
for the
is, it
record.
is on the petition, page of the petition, I was allowed to write read with Order 9 Rule 9.
Where's that?
Page number 59 of the main CRP petition.
Page 59, okay.
Page 59. Annexure 16. There in the matter of a petition under Order 22, Rule 1, I had written first for substitution of the plaintiff. In the court, I was allowed to add this read with Order 9, Rule 9 for CPC for restoration. And in the prayer also, I was allowed to add at the end, after in place of substitute, etc., in place of late Respel Tarang, and restore the TS number so and so to file. That was allowed.
Where the dismissal order?
Impugn order is. This page 57, 58, my lords. 58 is the handwritten one. 57 is the typed order. The plaintiff absent, defendants present, through counsel.
No, the order dismissing this your order
fine,
application
17.
under this order 22 and whatever.
That your lordships will find in my affidavit.
Yes,
it
was missing. That's why he had filed one affidavit.
Why you didn't annex it in your minute? If you come against that order, correct?
No, my lord. No,
I have
my
not
lord.
come against that order, my lord.
Then what are you
Because
submitting?
that was a wrong passage, so there was no point of coming for that only. Because
What
from
is the matter
ministerial
here?
stage, it was a wrong path.
My lord, he files this application in 2018, my lord. Certain corrections were permitted to be done. He does not approach this court immediately. He proceeds with that application. After that application is dismissed under Order 9, Rule 9. And it was dismissed on the ground that he did not file any condonation application.
That was also one ground then.
And this is an appealable order, my lord.
Now the condonation for...
No, okay. Now you're here under what? Against what? Against the dismissal order of 2017?
Yes, my lord.
Yes.
So you want to just discard everything that's
Yes,
happened?
because that order is a nullity in law. Because that order had been passed against a person who was dead on the date.
Will require a long hearing then. I have the authorities.
Yes, my lord.
Are you here today?
Yes, my lord. Actually, finding an authority only, I had come to know that this is the problem.
Or the entire thing's been abandoned. The other without any, you didn't file setting aside that this is the problem. Nothing.
Nothing, my lord.
Similar
2018, my lord.
Coming across this judgment only, I came to realize that both parties were traveling in a wrong path. Kerala High Court, my lord. Stella Pereira, Blaise Pereira versus Adima Abdul Latif, passed on 1st November 1968. Equivalent, citation AIR 1969, Kerala 286. May I read out, my lord. This civil revision petition attacks orders passed in proceedings.
Hold on 1 second. 1 second. This matter deserves more hearing. Today we're strapped for time.
Yes,
so we'll post it. You bring more authorities.
Yes, ma'am.
This one is that, see, but Order 22 application has to be within time also.
Yes, ma'am.
Whatever it is.
Now, my lord,
Now,
another
when you file
authority.
orders, see,
another authority
Mr. Bora, please listen. Please listen. If you come substitution, whatever it is, wrong forum, right forum, left forum, whatever, you have to come within. If you have to come, if it's within time.
Yes, my lord,
And
another
Order
authority
22.
I want
If
to.
it's not within time, whether it might be a wrong application, it has to come with a condemnation application for the court to consider.
That is what
now,
my lord.
what you have done there was that the court allowed you to file, together Order 9, Rule 9.
Yes.
Might be wrong, might be right, but the thing is that was there ever a condemnation application ever on record before the courts below? Forget your wrong way or right way.
Yes.
Did you ever file a condemnation application?
No, my lord, but then
You came to learn about the dismissal of the suit
My humble submission is that there was no need for a condonation petition.
Please listen. You gave, the suit is dismissed on 12/9/17, correct?
Yes.
Now you said you went and filed your substitution application on 20th/3/2018.
Yes, madam.
Then you realized that the suit had been dismissed for default.
Yes, madam.
Now, what was the action you have taken? Immediately, if you'd filed an application for restoration also,
no,
separate and even substitution.
When the case is dead, my lord, and
what do you mean the case is dead?
Without substitution, plaintiff is dead. Without substitution, how can restoration be
They all have to come together.
Had to be together.
Yes.
So court
now,
allowed me
then did you ever file an
only,
application
and at that
now,
point
even for
of time,
restoration, did you file application for condonation?
nothing was
You did
thought
not.
about the condonation. Now
Then-
later,
and then again you're stuck here.
later it was realized that.
Unless you argue, but then,
I have a.
but then the fact remains that.
And the support of judgment of our High Court only.
But no, we'll hear it. We'll hear it some other time. With no condonation application, how do you expect to maintain applicant throughout the process? Wrong way, right way. He might have gone the wrong path, right path. But at least one thing is that for the court to consider it,
Holding the condonation as 30 days, that is the mistake. But actually, the condonation has to be limitation has to be 3 years. In this case.
You argue that?
Yes, madam.
Item number 4.
Yes, this matter for
90 days, my lord, for Order 22, Rule 3, my lord.
No, if you don't bother to put condonation application, how do you expect the court to consider it?
Order is not under Order 9 Rule 8, so Order 9 Rule 9 will not be applicable.
And at this, you've not even challenged that order now. You've come against order of dismissal only.
That's what I'm challenging now in this.
No, how can you haven't even challenged that order also?
Didn't get a chance till I was there. Otherwise, there will be a res judicata if I bring the same subject to another court, my lord. That's why I was engaged in that court only.
You're tripping yourself.
Under the
Anyway.
wrong path only, I had been there.
This is a matter for admission hearing on so and so. Yes. Yes. Objection filed.
We have filed an objection.
Look, the objection has been filed. In this case, we are basically bona fide purchaser, and we have initiated with the construction of a substation.
Yes. You are bona fide
purchasers, my lords. Our status is of that of a bona fide purchaser. We were not aware about what is the dispute, my lords, which is going on between the parties, the main parties to this petition. And we purchased a land, my lords, at, my lords will see at page 11 of my application. Page 11 of my application, my lords.
Yes.
This is, my lords, the no objection certificate which has been issued by the Darbar, and it says, my lords, I, Darbar of so and so, give as a proof this NOC so and so for and have no objection for construction of 33.11 kV substation MECL measuring so and so square meters, my lords. And my lords,
let them be pleaded.
But pleading here, we say bona fide purchasers. The fact remains that this court, by page 25, order dated 12/8/2022.
12/8
in their application only.
Page
25.
Yes.
This is the order passed by this court, heard so and so and so and so and so. Civil revision petition is admitted for consideration. Call for the lower court records. This there. In the meantime, status quo as to the sued land shall be maintained. So, the sale deed was executed after the passage of this order.
By Mr. Lindor's client.
Yes, and that is why also we have
Why
filed.
do you do it then?
File the suit also.
That is the decision of the clan. It's not the decision.
That is why
this
this
goes against the order of the court also.
Yes. How can that be possible?
That they've done.
We'll implead them because they might be affected anyhow. I've seen the objection filed by the petitioner to the miss case number CRP number 9 of 2024. Stop in this application for implement of, this is the Meghalaya Power Distribution Corporation Limited as respondent. This application for has been objected to by the writ petitioner. Writ petitioner, right?
No, this is the revision.
You are the?
Revisioner. It's a civil revision.
Oh, sorry. Has been objected to by the petitioner on the ground that the alleged sale of land between the respondent, that is respondent in the main
revision.
In the main room, that is you are
Number 1 and 2.
respondent.
Two respondents are there, Mother. Two respondents are there.
Representing.
My lord, so far as respondent number 1 is concerned,
he died.
He is already dead. In fact, the appeal was filed by the then acting Lingdo. And the
Now you only
against
represent this Orlan Palyar.
Orlan Palyar.
I'm representing only Bresswell Palyar, who had filed the appeal before the court
Then
of the...
this one is by. Then Mr. Dingdo, then
they'll have to implement.
now you substitute Bresswell
Now
Palyar,
the
right?
difficult.
That means you are respondent number 1 now.
Now difficulty is
No.
I'm removed also. The Lingdo
Now
now
the
is
acting Lingdo also another. If your lordship will recollect, there was this
Oh.
petition also. So now even
Confusion confounded.
yes.
now we reverted back to the same position. Now Bristol Palyar's nephew is the acting Lingdo, who has been removed by this honourable court in the last round of litigation.
So you are representing nobody now.
That's why I'm in a kind of a fix. Very anomalous position in so far as I'm concerned.
And who's Orlan Palyar?
Orlan Palyar must be one of the clan elders.
He was never served.
We had appeared, both 1 and 2. I think it's on record for the respondents.
At least help the court.
Bresswell Palyar is the one who has signed it, because Dolly
Fine,
Palyar is no
fine.
more there.
Let's look at the appearance. Bakalat. You the respondent.
I'm appearing for 1 and 2.
1 and 2.
Let's be
One
clear.
and, it has to be 1 and 2, man.
1 and 2.
You be clear about who you're representing, and if you're not representing number 1 anymore,
Now the difficulty
then
is
who's come and pays for number 1?
the acting Lingdo who was removed by this honourable court because the
This is the
appointment of the
is
acting
from
Lingdo was
Lower
challenged.
Yes. Yes.
Now we reverted back to the same position.
No, what happened to that position? But then they're
Now I'm
supposed to
removed.
appoint another
Now what has
person.
happened, my lord? After the
Inquiry.
after the inquiry, the Lingdo has
is
been removed by the CM, and a new acting Lingdo has been appointed.
He's in place now.
No, he's the acting Lingdo. Now that acting Lingdo is the same acting Lingdo who was removed, who was...
The complainant.
Yes.
So that the court, and I remember that. I noted that.
So
How
now-
can the complainant become... Now,
So now, so
your
far as I'm
vakalat is not on
concerned-
record. Did you ever
Now-
file a vakalat nama?
For Bresswell Palyar, yes,
Where-
in this
where's-
originally.
For both.
Originally. Because at the time this revision was filed, one Mr. Stupinely was the, Bresswell Palyar was the acting Lingdo. Thereafter, they had a full-fledged
He
Lingdo.
came in place of this Bistan Palyar.
No.
Bistan is a petitioner, sorry. Okay.
After Dolly Lingdo, Dolly Palyar came Bresswell
Dolly
Palyar.
Palyar died.
Yes.
Then Bresswell Palyar
Then
was
you
the acting.
represented the person who stepped to his shoes.
Yes, who was Bresswell.
And the second respondent also.
Now, Bresswell is no longer acting Lingdo. They had a full-fledged Lingdo who was then removed by the...
I think we'll just leave it, we'll just get correct instructions and we'll have it after 1 week. Yes, as there's some confusion about representations made on behalf of the parties. This is matter, along with the missed case, after 1 week. At least come instructions, whether what's situation on the ground. But if we correctly remember, order has been passed that they appoint, that they select a new acting leader. Mr. Nongpure was there. You're the acting lingdo.
Lordship, I was the lingdo. I was suspended. I approached your court, this court. This got directed to proceed with inquiry. Inquiry is conducted. Now I've been removed. Now there's a new lingdo. Lordship.
Who's the new lingdo?
New acting.
High Court lingdo.
Who's he?
Acting.
Who's the acting lingdo at that time?
And that particular person happens to be the nephew of the president of this
chief.
No. The
Briston, who was a petitioner.
petitioner
So
in this
now you're
division.
on the same side.
Yes. So it's very difficult for me also now to appear here.
Occasion also, Your Lordship had said that if we could come to a compromise, time was given if the parties could.
The Mr. Lindo is nowhere then.
Exactly.
That's why anybody. And who's paying him to come and stand in court?
That's the only
Our difficulty is because our project has been stalled. Meanwhile, the parties are disputing these aspects.
But that's why we filed the suit also, my lord. At the first instance, it's because of the lingdo. The lingdo has no power.
But that suit is with regard to the forest. Only with regard to felling of trees.
You come with instructions. Ms. Nongpur also, you can make submissions. You know, not a party. The next state, yes, list the matter so and so. Mr. M. Nongpur, who do not participating in the proceedings or engage on behalf of any party, submits that in other collateral proceedings, the acting lingdo, who was.
No, the lingdo was suspended.
Oh, forget it then. How many? List the matter after 1 week is for the.
Obliged, Lordship.
Item number 5.
Yes.
Please, Your Lordship. Lordship, service notice and the newly impleted respondent has been affected. Your
Yes.
Notice
Speak
is.
a bit louder.
Lordship, the notice and the newly impleted respondent. Newly impleted. No, Your Lordship. Already delivered, Your Lordship. It's shown as delivered, Your Lordship.
She was delivered. You are appearing.
I'm appearing for the respondent 1 and 2, Your Lordship. GHADC.
The office note indicates that service report not complete. Mr. Kriam submits that the newly implemented respondent number
3 and 4. 3 and 4, no?
Lordship, he will be impleting respondent number 3 and 4, Your Lordship.
not yet completed.
Lordship, we have filed a missed case, Your Lordship.
It's not completed as yet.
Substitution. My apology, Lordship. It's substitution. I apologize, Your Lordship.
To substitute who?
Respondent 3 and 4, Your Lordship.
Yes.
Respondent 3 and 4, Nakama.
3 and 4. It also indicates that notice not been received yet on the proposed respondent stop. Though Mr. Kriam submits and notice been served. Let council put for the budget file a service for after indicating service on the said substituted respondent. Respondent sought to be substituted, yes. Yes, after 2 weeks.
Item number 6.
Last time, no orders.
Lordship, affidavit on behalf of respondent number 5. No, Lordship, it has been sent for final vetting, Lordship. We are awaiting.
Number 6. Yes, Ambassador Pradhan pays for further. All right. 2 weeks.
3 weeks time, Lordship.
7.
Highly obliged.
Yeah, Your Lordship, I am appearing for respondent number 12. Senate.
Yes. Orders passed. Connected.
Item number 6, exchange of bleeding completed already, ma'am.
Number 6.
Number 6.
Number 6 is number?
Connected. Number 7, my lord. Sorry, number 7, exchange of bleeding completed.
Yeah, that is okay.
Yes.
Number 8?
Number 8, my lord, I filed miscase for seeking impleadment, and my friend has also filed a show cause. So, if Lordship kindly consider for my impleadment.
Who filed show cause? But substantially, you are already involved in the proceedings. Is it necessary to be pleaded formally in this, in his case? It's your case, right? Now PC 416, your case.
Yes. My Lord, some specific government he has made in his petition that may warrant a reply from my side. I have also implemented him
Will
as
it
a party.
simplify matters or will it complicate matters?
No, it will not complicate.
It will simplify them.
Both of us are an interested party in the land acquisitions. So in view of that, I have also implemented him as a party in my writ petition. So I seek for my
Why are you objecting to this impleadment, Mr. Munkers? Come this side. Yes.
Worship, they have already filed a writ petition, fresh writ petition challenging the notification.
Who has filed?
The applicant.
Right.
That will be at item, Lordship.
9.
Item 9,
Okay,
Lordship.
right.
It's not necessary, Lordship, for them because they're challenging the notification in which my name has been reflected as the beneficiary.
So let him be, the more the merrier. Let him.
And Lordship, what has happened in the miscase, Lordship, there were only 5 applicants. However, in the writ petition, which is at item number 8, Lordship, 9, there are about 66 of them, Lordship. Now, only 5 of them want to implead in my case.
So what's wrong with that?
Lordship, 66 of them also have, where are the rest, Lordship?
They're in his writ petition.
Exactly, Lordship. There's no point in Lordship in the pleading, Lordship. And I'm already a respondent, Lordship, in their petition, Lordship. The pleadings will be same, Lordship. I don't think so.
That's what, if pleadings are same, what is the only thing grouse he has that you've made some statements there which he
There's no
feels
statement
needs to be rebutted.
Right. It requires to be
The
rebutted.
statement, the relief is only against the state, Lordship. And the private respondent number 3, who is the objector, Lordship. Nothing against the...
That's your submission. Senior counsel submission said no. You made some statements in the petition, and if the proceedings interconnected, it stands to reason that let them be implemented. Right?
Lordship, my submission that in my writ petition in item 8, there was a notification issued by the state whereby I've been declared as the beneficiary at the
They've
land.
already challenged that.
They've already challenged that in item number 9.
That's the challenge, sir.
My Lord, since we implemented him in my party, and he
You
claimed
filed
himself as
objection?
a party.
I filed objection.
Where's the objection?
His objection filed on 8/8/2024.
Let's see what you say.
That is his only ground. Now he claimed himself as a owner of the land, notified by the government.
Of your land?
Of my land. And
These
my
are-
names were reflected in the Section 11 and Section 19 declaration notification earlier. And without cancelling that notifications, behind the back of this Honorable Court and me, government has issued another Section 5, Section 11 and 19 notification again. There they have removed my name and inserted my friend's name.
Lordship, that, and
And therefore I challenge it. Now I come to know that my friend also filed a writ petition without impleading me. Therefore I filed an application for impleadment. Nothing prejudicial goes to my friend also, allowing me to be there. You see, I don't rebut some of his argument.
You represent Darbar.
I represent the Darbar, Lordship.
Then?
Therefore,
These are
Darbar-
Ilaka lands,
no,
Lordship.
Therefore, that is, he claims that it is an Ilaka land. All throughout, it is our land. Therefore, government...
Clan land or private land?
It is a private land. Therefore, government has, when notifying Section 11, 19, they have notified my name, that we are the beneficiary, we are the landowner. And we come before this court.
Subsequent notification is notified is Darbar land.
Darbar land.
And subsequently, without cancelling the earlier one, they notify fresh one, removing my name and inserting it. So I
And that
plead
is
for
the subject
impleadment.
matter of item number 9, Lordship.
Doesn't matter. It's miscase number 16 and 24. No objection has been filed to the impleadment of the applicant herein as party respondent on the ground that the same notification has been challenged by the said applicant in WPC number
WPC number 496 of 2021.
Of?
Oh, the second petition matter.
150.
150
Of
2024.
2020?
24.
12, no? That the same notification has been, as all of proceedings interconnected to avoid further confusion, the applicant and 4 others shall stand impleaded in WPC number 416 or 20 party respondents. I just need to make the necessary additions. Yes. as Mr. Chanaksu has already no further notice is
No further
required.
notice. I may be allowed to file short affidavit.
Yes, a 2-page affidavit is going to be filed. Okay. Ms. K
Obliged.
stands allowed, yes.
Lordship, so far as this
Deeply
item is,
obliged.
so far as this item is concerned, Lordship, I'm praying for time for filing rejoinder.
Which one?
In item number 8, Lordship.
Number?
In item number 8.
8 is what?
This is my writ petition in which senior counsel has been implicated. In there,
416 is getting a representation. Ooh. Number 8.
Item number 8, 416.
416.
416.
In 416, the respondents have filed the affidavit. I need some
For
time to
rejoinder.
file rejoinder.
Yes, Haju, and 416, Mr. Mulford, that the petitioner pays without 2 weeks and for rejoinder. List all these matters after 2 weeks.
150B, I have not filed an affidavit.
Yes.
I require some time.
2 weeks time?
Yes.
Lordship,
150 Haju in the atom. Mr. SN on behalf of the respondent pays for 2 weeks time. Nice. This matters together with 416 after 2 weeks.
Item number 10.
Very vexed matters, not only on.
Deeply obliged.
Item number 7 only.
Yes.
I'm only in item number 7.
Very good. Record Mr. Devaseva item 7. Yes.
My lord, the respondent is here to file an affidavit.
Well, so I may be granted about 2 weeks to file an affidavit in this. There was a direction to refer the matter under section 64. I don't know, there's been some misunderstanding of this order by the concerned authorities. We are advising them to take up the 64 application and refer it to the court.
We have already filed that, Your Lordship.
Yes. Let them file affidavit.
Yes, yes,
It's further time, further 2 weeks time is praise allowed for affidavit. Just thereafter.
Obliged.
Item 11.
Yes, Lordship. Is respondent number 6, the Deputy Secretary Government Meghalaya, Personal A and B, they have regularized the service of the petitioner. They have make a mention in the paragraph 5 of their affidavit filed by the Deputy Secretary Government Meghalaya, Personal A and B. So, Lordship.
So you want to close the matter now?
Lordship,
It can be closed, Lordship.
Can be closed, at least giving some time to complete because they are, I'm asking for
which
regularization
paragraph?
at the same time to pay.
Page 2, paragraph 5,
Yes.
Lordship. The affidavit filed by the respondent number 6.
Page 2, paragraph 5.
Yes, paragraph
Affidavit
5.
filed on behalf of respondent number 6. Page 2, paragraph 5.
Stop. Mr. P.T. Sangma submits that in view of the affidavit filed by the Deputy Secretary, the Government of Meghalaya, personnel and AR capital bracket B Department Shillong, wherein at para 5 it has been stated that the proposal for valuation of the service of petitioner with effect 19/4/2002 has been agreed to. Nothing further remains for consideration.
Lordship,
However, prays that a
I'm
time frame
grateful
be
to-
given for
Yes.
the entire process to be completed. Stop. Next, by MS and NG Shalla on behalf of the respondents.
Can I respond?
Submits that the matter can be closed at the stage itself.
1 to 4.
1, 2, 3, 4, and 6, Lordship.
1, 2, 4, and 6. Some matter can be closed at this stage itself. Accordingly, the matter stands closed and disposed of in view of the statement made in paragraph 5 of the affidavit or respondent 6, however granting the respondents 4 months' time to complete the exercise. This matter stands closed and disposed of.
Lordship.
Much obliged, Lordship.
Item number 12.
Lordship, I have
File
filed my
affidavit.
copy. I have filed my copy.
Already filed?
Yes, Lordship.
Number 4. 4? Yes, affidavit on behalf of respondents 1, 2, 3 that's already on board. So for MSEB Basa, please allow for the 2 weeks time to file affidavit on behalf of respondent number 4.
13.
Listen, Vinay.
Lordship, this was directed to be listed along with item number 3 on Friday.
Yes, this matter together with the QC number, so and so on. Yes.
14.
Please, Lordship. Lordship, the respondent, they are supposed to file their affidavit, Lordship.
Yes, MSEB pass out with the affidavit.
Lordship, we're yet to receive instruction, Your Lordship.
You're yet to receive instructions?
Yes, Your Lordship.
When was the matter filed?
It's filed on 28 June, Your Lordship.
Lordship, I pray for 1 week time we'll file it when...
You already have received instructions.
No, Your Lordship, I will go to the office today itself and ask for the
And
instruction.
government?
Lordship, I'm appearing on behalf of Mr. H. Abraham, Lordship. We're awaiting instructions also.
Okay, at least after 2 weeks to allow the petitioner to receive instructions to file affidavit, yes.
15.
Lordship, the state respondents have received instructions but require about 2 weeks' time, Your
What's the
Lordship.
matter about?
This is regarding appointment of a teacher. She was appointed, but again the approval was withdrawn due to some error on the part of the respondent number 3. So this can be closed, Your Lordship, after we file an affidavit.
The MS T. Hangi Leonard AAG with so and so submits that instructions have been received and that 2 weeks' time is required or 1 week's time?
2
time
weeks,
is
I
required
think.
for filing affidavit. This is matter of 2 weeks for affidavit. Yes. Sorry, you won't take the hearing because I've got to leave town. No urgent matter for hearing?
No, Your Lordship.
Never is also.
Yes. Yeah.